Yes.
Item number 24. In fact, the appellant's counsel is not present, but I had a talk with him. He's an outstation lawyer. He has been on field, madam. For a long time.
24.
Yes, 24.
Oh, the 16 matter.
Yes, that's why I would have. I'm ready, my lord. He's outstation counsel is from passing. I had a talk with him last time. He said out of station. He said, can it be done on 5th?
5th?
Yes.
December. What is there?
I could have.
You are the respondent.
I am the respondent. That is a difficult thing. Then if your lordship gives some any other day, next week, then I will inform you.
On the bearer of the 11th Council for the parties list this matter on 5/12/2023. Considering the matter is 2016, the matter is fixed and no further resolution here.
Very important. In fact, the dispute is dates back to 1991.
No further resolution.
Right.
My lord, I beg to mention one unnecessary matter for today, my lord.
What is this?
My lord, this is quashing petition, my lord.
Huh?
Quashing petition, my lord. Come on.
My lord, in item 15, I was supposed to appear on behalf of the respondent. My lord, can this be taken up after a week, my lord?
15?
Yes, ma'am. I've taken consent from the other side.
Affidavit in opposition has already been filed.
It's in orders. Orders,
Yes.
please. What do you want?
Next week for admission.
Mr. Learned Concept.
23.
He has an instruction to appear on behalf of the expert. Six sometime.
Well, let it be on 23.
23. Then this becomes listed on 23.
Obliged.
May I, Your Lordship? Lordship, I'd like to mention item number 8.
Item number
8, Your Lordship.
8.
Yes, Your Lordship. This matter, the conducting counsel is from Guwahati. So, due to some health conditions, he couldn't appear. He prayed that this matter can be fixed on 8th of December, Your Lordship.
On the prayer MSR Tapu.
Yes, Your Lordship.
That will counsel to the petition. List this matter on 8/12/2023.
Much obliged.
My lord, I would mention item number 20.
Item number
20.
20.
20.
Yes.
Yeah, this matter may be released on 21st December. I have taken the consent from the other party.
You are for?
I'm on the behalf of AK Professor.
Item 20.
20.
20.
Yes.
AK Procedural. Who is AK Procedural here? Huh?
Yes.
Item 20, nobody is there in the name of AK Procedural.
Your
Item
name is
20.
name is not reflect, but he's
Is a senior lawyer?
yes.
Senior lawyer?
Yes.
Designated?
Designated senior.
Okay. Mr. AMS so-and-so, Learned Counsel for the Learned Counsel appearing on behalf of Mr. Lucasto, then Senior Counsel appearing on behalf of the petitioner.
Yes.
Press for it, granted 2 weeks time. 2 weeks,
21 December. On 21 December.
4 weeks time. This matter on 24,
21st December.
21/12/2023.
And madam, here is one more matter, unlisted matter, IAS number 164, April 2023 in a make appeal number 5, 2023, civil United Indian on the behalf of United Indian Insurance Company. This matter may be released on tomorrow.
Why? What is the urgency?
Urgency is that
On behalf of the insurance?
insurance on the
Monday.
Uttam Udeka.
Monday.
No, Your Honor, this urgency is there because execution proceeding is going on this.
You cannot stay the execution proceedings.
But Your Honor, it's there. And for tomorrow.
Okay. Tomorrow.
So,
Lordship, may I beg to mention item number 16 with 17. I'm on behalf of Mr. K. Tama. Leading counsel is out of station due to some personal difficulties. Matter may be listed after winter break. Lordship.
Winter break,
Yes, Lordship.
it's too far. Mr. So-and-so appearing on behalf of Mr. Ketama, learned person for the petition. Press for and granted, 4 weeks time.
Your lordship.
This matter after.
17, there is an interim stay order. It may be extended, your lordship.
Okay,
Item number is criminal review, item number 17.
list this matter after 4 weeks. Interim order passed, earlier shall continue.
Lordship, I want to mention item number 23.
23. Okay.
The learned counsel,
On the prayer of Mr. So-and-so, let me counsel to the petitioner, list this matter after 4 weeks.
Lordship, I'm praying for taking up with IA in civil revision petition,
Unlisted.
taking up with IA. Unlisted. Actually, Lordship, I have filed IA yesterday, but because of wrong quoting of the provisions, it couldn't be listed, which has been corrected.
Take up tomorrow. Tomorrow.
Lordship, anytime the Kava may be conducted,
Huh?
anytime the Kava may be conducted, earlier,
It's good, let the cover be conducted. It's all right.
no, no, Lordship, the problem is
Are you sure this court will stay the cover proceedings?
already stayed. I mean, Kava proceedings were stayed by Sessions Court, which was vacated in CRP. So we are here for vacation of or alteration of the order.
Tomorrow, come prepared in tomorrow.
Lordship, the Kava may be conducted anytime. It's a third Parwana.
At this-
Third Parwana
at
had
this
already been
today,
issued.
I think by
No, your lordship, in fact,
by this date, by at this stage, at least Kaba also knows.
yes,
Without issuing a parwana and all those things.
yes. In fact,
Lordship-
I'm the petitioner in this matter, your lordship.
Lordship,
Kava has been
simultaneous,
postponed for 30 days otherwise,
Ah.
already. It was to be held on 10th, your lordship, which has been postponed.
Postponed.
Yes.
no, Lordship, but the conduct of the Kava members are
We'll
such
see
that they had.
tomorrow, it's okay. In any case, it's not going to be conducted today.
That's it.
Even if it's conducted, we cannot help it. Tomorrow.
Please, please.
My lordship, I beg to mention item number 18. Your lordship, I have a medical emergency, so I have to leave your lordship. So I seek your honorable, your lordships, that I have to file affidavit. I have filed my wakalat nama today.
You are for,
Respondent 1 to 6.
okay, Mr.
R. Raksa.
Learned counsel appearing on behalf, learned counsel submits that he has an instruction to appear on behalf of the respondents,
1 to 6.
1 to 6.
Yes. I filed
Respondent
wakalat.
number 1 to 6.
Yes,
For which he seeks sometime to file his counter affidavit.
yes.
Lordship, I'm for the petitioner.
Mr. So-and-so, Mark is present. So-and-so present on behalf of the learned counsel on behalf of the present. This matter,
3 weeks. After
Lordship,
3 weeks.
interim order
Three weeks.
granted earlier.
interim order was earlier shall continue. Okay.
Oblige.
I would like to mention, my lord, one criminal petition, my lord, one criminal petition, my lord, 64.
Next week,
My lord,
it's pending,
yes, my lord,
next week.
my lord,
Don't worry, I'm there for another 2 weeks.
yes, my lord. My lord, the case is listed on 20, my lord, in the James court, coloring. My lord.
Doesn't
Therefore-
matter, doesn't
Yes, my
matter.
lord.
Next week,
My lord,
if it's pending, had it been a refiling, that would have been it.
yes, my lord, the case is listed for, already for, 4 weeks, past, my lord, there was stay order, my lord. But the case is listed again, my lord, in the coloring, court, my lord. So, my lord,
Tomorrow, in
yes,
that
ma'am.
case tomorrow.
Your lordship, here. The petitioners and the respondents both are the same village, that is go to put to village.
Where is the interim order?
Your lordship, interim order is,
Page 29.
yes, page 29.
You file an appeal, there's a provision. After the enactment of Civil Courts Act.
No, your lordship, my prayer is that only that the village authority will decide. They directly no, without taking the village authority, because I am approached the village authority that is annexer.
You want that it
Annexer
should
for
be-
page
it's-
18, you know.
You want that it should be decided by the village authority.
Yes, yes, village authority is a procedure.
What does it mean by local mail order? What is this?
This local mail order is issued by the Gangbura Association, the Sagali Subdivision Gangbura Association.
Gahabura Association will
Yes.
be consist of the Gahaburas only and it's a village authority only.
No, you know, this is the subdivision level. Subdivision level. So my request is that the village authority will first decide it.
Who are the village authority?
Because there is sufficient EVs in the Gotuputi village. That is kindly in page 8, para 12.
Page?
Para 12 and page 9.
What?
This is the EVs. Page 9.
Page 9 is what?
This is the list of the GBs of the go-to village. That is sufficient of village authority that's here. This is the respondent, head GBs. Next is Tachitaji GB and
Have you filed
all are GBs.
Have you filed any objection against this local mail order 1411?
No, Your Lordship.
You filed an objection?
Because Your Lordship, I have filed the title suit before the civil division, senior divisions, UPR. Thereafter, what if you know the notice giving information to this Gangra Association. Meantime, the Gangra Association postponed the.
Let us do one thing. It is fixed on 21/11/2023. You file an objection to this order. We'll see if he doesn't respond anything, we'll pass appropriate orders on that day.
You know that the interim order may be given till then.
You first approach them. We'll fix this matter on 20 Monday. Monday we'll list this matter.
Because the Monday is the date of the
21st.
fixed by the village.
That is 21st. 21st is Tuesday. You file an objection to this because you file an objection to this order saying that the disputes, the jurisdiction is within the village authority of such and such village.
Yes.
So therefore, it should be taken up by the village authority of the particular area.
Because
if they doesn't listen to you, if they doesn't, consider your matter, will pass appropriate order on Monday.
May submit the concerned association, Your Lordship.
Yes. Because you have been given the notice.
Yes.
So you file an objection. Today itself or tomorrow, list the matter on Monday.
Okay, that's true.
On the prayer of Mr. T. Gary, Learned Counsel for the list this matter on the motion hearing. In the meantime, the Learned Counsel for the petitioners may file appropriate objection to the order dated 14/11/2023, indicating that the disputes is within the jurisdiction of the particular village authority, which the association Gahabura doesn't have a jurisdiction to decide the matter.
It is a 430 application minutes.
Yes. Heard Mr. So and so, Learned Counsel for the petitioner, applicant. Also have MS PG learned additional people for the state. Call for the case diary.
Yes.
Certain
pending
petition-
production of the case diary, in the event of arrest, the accused Sri so and so
Corner Purita.
shall be released on bail. On furnishing a bail bond of rupees 50,000. 50,000. What is the
420 and my lord's 120B.
So what is the dispute involved? The value of
Dispute, my lord, the person petitioner informant went for a contract, my lord. He contacted the petitioner that come let us go.
what
for
is the
contract.
value of the contract?
Manoj, it's very, it's very advised.
86
No, Manoj,
lakhs.
contract value
86
was.
lakhs, your lordship.
No, no, that's.
25,000
My lords, 25,000.
on the following grounds.
Any date?
The accused shall appear before the investigating authority within 2 days,
2 days only. He's having dengue, my lords.
within 7 days
7 days.
from today. The accused shall not tamper with the evidence. And what else you want?
Yes,
What
lordship.
else you want? Conditions?
If and when called for, your lordship. If
if
and
and
when
when
called for.
Call for attend the court and the, not the court, the investigating authority. Where he resides?
He resides in Guwahati.
Metro. Kamil Rural, my Polas by.
One surety of, local surety, if your lordship.
One surety of like amount.
My lords.
Leave it.
List this matter after 10 days.
Yes, your lordship.
10 days. Yes.
What for the city?
Yes,
Alright,
sir.
you just read this same, this thing, heart so and so, so and so, so and so. This is an application so and so, huh? You just write that. Call for the city. List this matter on
23rd, your lordship.
24.
Then, okay.
24.
Much only. Deeply obliged, your lordship.
I filed,
Is that, huh?
I filed 2 bail application, item number 4 and 5.
What is the offense? Offense?
Offense is 380. 380.
It's a post arrest bail.
Yes, sir.
Post arrest bail.
Yes, yes.
Regular bail.
Regular bail.
Same order.
Yeah.
You just take it.
Maybe fix on 22,
25, 25.
25.
25 is working day.
Maybe 20 or 22.
Huh? When you were arrested?
22. This one.
When you were arrested?
Yes, sir.
When you were arrested?
26 August 2023.
Okay, then in that case, 22.
Yes.
Can you produce a CD on 22?
From Nalagan police station.
You see?
20, yes.
22.
Highly obliged.
Next.
Six, criminal revision petition.
May I please?
Yes.
My lord, here, my lord, this is a revision petition, my lord. The petitioner, my lord, is the father of the deceased, my lord. Who died, my lord, because of the assault done by the accused person, my lord. By this impugn order, my lord, the learned trial court has discharged 2 accused persons out of the 3 accused persons, my lord. And the reasoning, my lord, where the learned trial court has gone wrong is, my lord, that at the framing of charge, the nature of inquiry, my lord, the scope of nature of inquiry at the framing of charge is quite different, my lord. It is here not something, my lord, where we should go for appreciating the entire evidence, weighing the entire evidence, and seeing the probability value of the evidence, my lord. The law is very settled, my lord. It says, my lord, that contradiction, consistency, all those aspects cannot be considered, my lord, at the stage of, my lord, framing of charge. What is to be considered only is, my lord, whether there is a prima facie case or not, my lord, whether there is any material or not. The impugn order itself, my lord, is contradictory. Why I am saying, my lord.
Who is for 2 and 3?
You know, still time for the 2 and 3.
Yes. Are you ready?
Is.
Well, the impugn order itself is contradictory on the face of record. Why it's saying, my lord? That first impugn order is saying that one of the injured witness, John Tapping, he has stated under 164 statement that all the 3 accused jointly assaulted the victim. And on the other hand, the learned trial court has erroneously drawn the conclusion, my lord, that too at the stage of framing of charge, saying that this particular witness is an interested person, which is not permissible in law, my lord, because it is not the stage where the conclusion can be drawn whether a particular witness is a interested witness or not, my lord. Otherwise, my lord, law also says, my lord, that even if it is an interested witness, even after the entire trial is over, my lord, even a person is an interested witness, it doesn't mean that his entire evidence has to be discarded wholly, my lord. Not at all. Only it requires that, my lord, his evidence has to be considered cautiously and had to seen for corroboration from other aspects. Having said all this aspect, my lord, I'll just take to my lord to the impugn order, my lord. Then I will
Just wait. There's an order that there's a delay of 29 days.
my lord, this has been condemned, my lord.
Okay.
My lord.
Yes,
May I straightly take to my lord page number 17, my lord.
17.
17, 17, my lord. Page, my lord. For the 6th line, my lord. Then after my lord, this findings of the court, my lord, rather I will take the findings of the court, page number 20, my lord. Para 10, my lord. I'll just read out, my lord. As regards to A2 and 3 are concerned, this court, after minutely perusing the materials on record, has found that although they were alleged to be the part of quarrel that took place between A1 and one John Tapping, who later called the deceased for his help, but could not find any materials from where it can be gathered that they were party to the physical fighting between A1 and the deceased. Now, Your Honor will see this is, my lord will see this is very important. The next line, my lord. The only witness who stated that A2 and A3 were also assaulted the deceased is John Tapi, who called the deceased. Although this witness has not stated anything to that effect before the IO, but he has improvised his statement by stating the same before the magistrate, which is recorded after 45 days of the incident. This is the person with whom A1 initially fought with it and also alleged that A2, A3 also supported the A1, because of which this person called the deceased for his help. Therefore, he is an interested witness. As such, only on the basis of the statement of this witness, as the remaining eyewitness of the incident, including the girlfriend of this witness, has not named the A2 and A3 to be the party to physical fighting between A1 and the deceased. That apart, there is no any other material to indicate the participation of these two accused in physical fighting between A1 and the deceased. Therefore, this court is the opinion that the trial against these two accused will be unnecessary and futile. Hence, A2 and A3 are entitled for discharge on the ground of insufficient materials. Accordingly, this court so and so. Now, I pause. Now, my lord, we can see from the nature of the discussion in paragraph 10, whether my lord will consider whether this is permissible at the stage of framing of charge. The settled proposition of law, my lord, I will cite in support of my contention, my lord, that it says, my lord, this roving inquiry, my lord, at the stage of framing of charge cannot be looked into, my lord. Only the trial court has to see at the stage of framing of charge whether there is any prima facie material, if remain unrebutted, whether it will lead to the conviction of the accuser's person, my lord. There has to be a presumption, my lord. That material has to be looked at. Now, my lord will see here what the learned trial court has done is that now he started, my lord, analyzing, appreciating the entire evidence. Now, my lord, very interesting. Now he is declared without even before holding the trial that this John Tapping is an interested.
So according to you, at the stage of framing charge, it has to be, you cannot look into the evidence.
It has to
and
be.
it has to be in a sort of slipshod and.
No. Law says, my lord, it has to weigh, evidence has to be looked.
Certain thing has to be considered.
But it has to be considered. but not robbing inquiry. Has to be considered, my lord, for a limited
No,
purpose.
no, according to it may be robbing inquiry, but according to the trial court, he has considered something.
My lord will consider, my lord, this conclusion, whether this is permissible or not. This kind of detailed discussion, whether permissible under the nature and scope of
No,
section
cer-
227.
no, no, certain analysis has to be there. It cannot be a mechanical kind of framing a charge.
No, not mechanical.
That should not be a, I think,
The law says no, because at this stage, what happened, my lord? Because it is the stage where there cannot be the stage where the defense evidence can be laid. Here, what the law says 227, the documents as furnished by the prosecution, that has to be only looked into, not beyond that. And after taking in its entirety on its face value, my lord, because, my lord, truthfulness of the prosecution
it's a
history,
matter of trial.
yes, cannot be looked into, my lord, how it is possible, my lord, at all, my lord. Now, my lord, in the case, it is not something I am saying, my lord, whatever the prosecution file, court will blindly accept that. No, that is not my
Heard
case.
Mr. R. Sonalan, counsel for the petition, also heard Mr. P. That is additional people. Your,
I am for, I am capable.
Mr. So-and-so for respondent number 2 and 3.
Yes.
Admit list for hearing after 3 weeks.
My lord, then 2 weeks, my lord, because, my lord, trial is going on, my lord, against one of the accusers.
Okay.
2 weeks.
2 weeks.
Much of it. Please, sir.
Oblige, your lordship.
Yeah, Lordship.
Yes.
Lordship, by senior Mr. Parkin is on legs at the court number 1. Kindly this matter may be passed over forever.
Week.
No,
After some time.
yes. Oblige, Lordship.
Yes. Yes, yes. Cannot help it out. Mr. Singh. Yes, Mr. Singh. Yes, Mr. Singh.
Oh, my lord, I'm so sorry for keeping you on hold. My case, my lord, is, yes, my lord. My case, my lord, is that an FIR has.
Just wait. Do you have the case ready?
Yes, Lordship, my colleague MRK.
Just wait. Whether they have the case. Yes, do you have the case ready?
Lordship.
If not, we'll take up tomorrow or next week.
Lordship, on last occasion, Lordship, the interim may be considered only after receipt of case diary and the submission of the relevant
No, that's
document.
why you have the case diary.
Yes, I have case diary, but, and they have also need to submit their relevant document, Lordship.
Which we have submitted.
Yes.
My lord, the FIR, if it is read, my lord, it starts at page 10, annexure 1.
Yes.
May I take your lordship to the relevant portion, my lord? That is, starts at page 14. The first 4 lines, my lord. It is to inform you that I am a contractor by profession and I have undertaken construction of new district hospital building at Bombila. I have engaged one Sri Jahirul Islam, son of so and so, permanent resident of so and so, for completion of works connected with painting, false ceiling, installation and fixing of aluminum doors and windows of the district hospital building. Earlier, I used to purchase false ceiling, aluminum and other building items from a hardware shop called Padmapati Aluminium Hardware, Bherpada, Charali, Guwahati. Sri Jahirul Islam came to me and told me that he has known one hardware shop at Guwahati which gives false ceiling, aluminum doors and windows at a very cheap rate. Sri Jahirul Islam gave the name of hardware shop owner as Sri Rajan Das and introduced him to one of my construction partners, namely Sri Sunil Cheda, over phone. Sri Rajan Das told my partner that he runs a hardware shop at Guwahati in the name and style of FRS Enterprise and sells the item at a cheap rate. Sri Jahirul Islam through WhatsApp number sent invoices of FRS Enterprise to my partner amounting to rupees so and so of such and such date. We accepted the invoice amounting to rupees 5,50,690, being the lowest rate for the items. On 22nd of September 2023, Sri Jahirul Islam came to me and told me that the invoice items were already loaded in a vehicle for transportation to Bonbila from Guwahati. And he requested me to deposit the requisite amount as early as possible in the account of FRS Enterprise with account number so and so of the State Bank of India. On his persistence request, I deposited a check bearing number so and so from my TD Enterprise account Bonbila with amount of rupees so and so. The amount was successfully debited in the account of FRS Enterprise on the same day of depositing the check. On the following day, that is on so and so, I was told by supervisor Sri John Akka that Jahirul Islam sneaked out from the worksite district hospital Bombila in the night of 22nd of September 2023, the day when the amount was credited in the account of FRS Enterprise. I also came to know that through my supervisor that some false ceiling and aluminum door and windows items and a pair of gas cylinders were stolen away by Sri Jahirul Islam from the work site. When I contacted Sri Jahirul Islam over phone, he flatly refused to repay the transferred amount to me and also refused to send the invoice items to me. The way amount was taken out from me, it shows that Jahirul Islam was never intended to complete his works. Rather, from the very beginning, he had an intention to cheat me, and to accomplish his intention, he has introduced Rajan Das. I pause for a moment, my lord. Two things are loud and clear. One, that Jahirul Islam, which is the petitioner, which is me, had been known to TD Enterprise or to its proprietor for a quite long period of time. Now, in what connection we had got introduced? He engaged me as his contractor, subcontractor to do certain things. I started the work, and for the last around 1.5 years, I have been doing my task. Now I am to get from him around rupees 27 lakh. Despite persistent request, my lord, umpteen number of times I requested, he did not make the full payment. What I have done, when he paid me the 5,50,000, I have set up this amount and I have already informed him. It's not that I have run away with any money which is not belonging to me. It's my money, my lord, because still I am to get rupees 22 lakhs. It's a pure and civil dispute between the original contractor and the subcontractor.
Okay.
And this, may I? Two things, my lord. I have submit additional affidavit, my lord, where I have also issued a pleader's notice to Mr. Norbu Sharing. Your lordship will find, which I have subsequently annexed as per the direction of the Honorable High Court. If your lordship comes to the additional affidavit, my lord, page 42, a pleader notice asking him to pay the balance dues. And I have already responded to section 41A notice, my lord, which is I have already annexed along with the FIR in the original application, my lord. and I have given the full information to the concerned officer in charge. I have also provided a pen drive along with my letter to the officer in charge where there are recorded conversation between me and Tenzing Norbo, as also between me and Tenzing Norbo's wife, which clearly indicates that I am to receive my lord around 20. My lord, may I also one more thing, my lord?
Just wait. Did you appear before the IO?
At that period of time, my lord, I was away. So I wrote a letter to the officer in charge asking him time and also informing him as to what I am to say. The entire statement I have already forwarded.
Yes.
That I have also enclosed, my lord. May I also crave for the liberty, my lord, to show annexure 14, page 39. This is very much relevant, my lord. Annexure 14.
39 of your additional affidavit.
Yes, my lord.
Additional affidavit or made petition?
Additional affidavit, my lord. Page 39.
Yes.
Annexure 14, your lordship will find the amount I have already received and the amount for which this present affair has been lost, which I have already indicated there in the below, which I have adjusted. Under the Contract Act, my lord, this is my right to adjust.
Okay, it's okay.
I have a right to adjust.
It's okay. Yes, madam. Anything else? Anything there?
Lordship, the objection of this bail petition was, Lordship, because he's already been served 41, Lordship, on section 41 CRPC, where he's been called for the statement, but he did not turn up, Lordship, and he keep on
We'll ask him
responding.
to appear.
Lordship,
We'll grant a bail and ask him to appear.
and give his statement. Yes, Lordship.
Mr. Singh will grant you a bail, but you have to appear within 5 days.
My lord.
5 days.
10 days, my lord. 10 days, my lord, kindly give me the liberty. 10 days.
At Mr. S.K. Singh, learned senior counsel.
My lord.
And also heard for applicant accused, and also heard MS L. Hage, learned additional PP for the state. By filing this application, the accused applicant, by filing this application under section 438 CRPC, so and so, the accused applicant has prayed for privilege of pre-arrest bail in connection with Bomdila PS case number 12 of 2023 under section 420 of 370 of Indian Penal Code. Why 379?
Theft, Lordship.
Yeah.
So as per the allegation, Lordship, he had taken some Lordship, material, Lordship, without knowing the owner of it.
The case set up by the prosecution is that once he Tenzing Norbo, the proprietor of MSTD enterprise has lodged an FIR before the Manila police station, alleging that the informant, the accused applicant had engaged the treasurer for completion of works connected with painting, public pole ceiling, public installation, fixing aluminum doors and windows of the district hospital building. It further alleged that the accused petitioner applicant during the course of his employment, in collusion with one Rajendras, has cheated the informant and thereby the accused petitioner alleged to have been cheated of rupees 550,690, 5,50,690 by deceitful means from the informant. It further alleged that the accused applicant has stolen away some valuable articles from the construction site. Next, on the basis of such FIR, a case has been registered as Bombila case number 12 of 2023 under section 420/379 of Indian Penal Code. It is noticed that this the notice under section 41 has also been served to the applicant, accused to appear before the IO on 25/9/2022. Mr. Howard, due to certain difficulties, he has responded back to the investigating authority, Mr. Singh, learned senior counsel, submits that if at all the dispute is purely of civil nature, which there cannot be any criminal liability, criminality on the part of the accuser. MSN Hage, learned counsel, learned additional PP, produce the CD. What is there? Anything? MS Swenson, huh? So, addition PP, while referring to the status report submitted by the IO, submits that is the accused applicant has been served a notice under section 41 of CRPC for her mother. For her mother. This Howard is not cooperating with the police and has not appeared as on that. Rather, it is absconding. Since the accused applicant is absconding and not cooperating with the investigating authority, the prayer of the applicant accused may be rejected at this stage. Next one, on having considered the submission of the law of counsel for the petition and also considering the, after perusal of the case that listed by the learned additional bill, this court is of the view that if at all view that this court is of the view that the dispute, if at all, appears to be beyond a civil nature. Mr. However, without commenting on the nature of the offense, this court deem it fit, deem it appropriate to grant free respect, grant the privilege of free respect to the accused applicant. Accordingly, the accused applicant, in the event of a shall be released on the bail bond on furnishing the bail bond of rupees 50,000 Would surety of like to know. To the satisfaction of the investigating authority on the following conditions. Mr. The accused applicant shall appear before the IO within 10 days from today. Then next, the accused applicant shall not tamper with the evidence. Mr. The accused applicant shall appear before the investigating authority as and when called for. The reciting of
Lordship, it's outside the lordship, so that lordship, he should be take permission lordship.
how
I-
do you ensure? How do you ensure your appearance? You are
I
from
will appear, my lord.
Gosa.
I am a permanent resident of Tezpur town, my lord. I will definitely appear, and I assure the honorable court, as and when directed by the IO, I will keep appearing. So long the investigation is on, my lord. May I pray two more things, my lord? I have already provided a pen drive to the investigating officer in compliance of section 41A.
Just wait. The accused applicant shall appear before the IO once in a week till the completion of the investigation. Once in a week after
My
10
lord,
days.
my lord, kindly relax. Otherwise, he is a laborer, subcontractor, my lord.
No, he is a
15 days,
contractor.
A fortnight, my lord, a fortnight, he will definitely appear. Fortnight, my lord.
Huh?
It will be cumbersome, my lord, to keep appearing every week.
Fortnight. It's okay.
Fortnight, my lord. My lord, may I add one thing? The investigating officer shall consider.
Disposed of. That's all. Thank you.
Obliged.
Next.
Lordship, this is.
Hmm?
Lordship, only this is interim lordship.
No, I'm disposing of.
No.
The anticipatory bail, pre-arrest bail.
But otherwise, lordship, we should see
Nothing,
the.
it's just a dispute between this contractor and his engaged.
Otherwise, statement should be.
There's nothing. Is there anything?
The lordship, once he appeared before the IO, a statement should be recorded, lordship. After that, next step.
Obviously. That is the job of the IO. Where you should they say that. Once he appear, in the event of arrest, he'll be released.
Then any of the
obviously
condition is failed, then it may be cancelled, lordship, this bail bond, because we.
In the last, just wait. Hello. Last time, in default, in the event of failure to abide by any of the condition above, the order of bail shall remain,
Cancelled.
shall stands
It may be-
automatically cancelled.
No, sir.
But he's not there. Anyway.
My lord, in this case, my lord, on the last occasion, the scan copy of
El Hagel submits that charge sheet has already been filed.
They have sent the charge sheet, lordship. They, from PS, the charge sheet with, is sent to the lordship, court lordship. So we have to call the scan copy answer from the concerned court lordship.
Before. Before the.
Lordship, session code 0, lordship.
Session, 0. The scan copy of the LCR, scan copy.
Scan copy of the LCR.
LCR may be called for. List after 3 weeks.
my lord, can it be 2 weeks, my lord? It's after 2 weeks.
After 2 weeks.
No, sir.
Yesterday matter for default bail, and your lordship, the Rakesh Kumar 4 case we have relied yesterday. The paragraph is here 84, your lordship. The concurred by the Justice Gupta on finding of Justice Lokur. In para 84, your lordship.
Para 84, nah.
You read it. I have this. You read it.
May I read out, your lordship?
Yes.
Okay.
Para
84. Reported in 2017, volume 15, SCC 67.
in view of the above.
Yes, your lordship. In view of the above discussion, my findings are as follows. I agree with both my learned brother that the amendment to the Prevention of Corruption Act 1988 by the Lokpal and the Lokayukta Act 2013 applies to all the accused charged with offence under this act, irrespective of the fact whether the action is initiated under Lokpal and Lokayukta Act 2013 or any other law. 84.2. Section 167(2)(ai) of the code is applicable only in cases where the accused is charged with offence punishable with death and any lower sentence, offence punishable with life imprisonment and any lower sentence, and offence punishable with minimum sentence of 10 years. In all cases where the minimum sentence is less than 10 years, but the maximum sentence is not death or life, then the section 167(2)(a)(2) will apply, and the accused will be entitled to grant of default by after 60 days in case of charge sheet is not filed.
So according to you,
It's 60 days, your lord.
He's entitled.
Yes, your lord, 60 days, your lord, because minimum punishment is not 10 years and the punishment is not extended to life or death. So it come into the second observation, 60 days, your lordship. And your lordship, charge sheet has not been filed as per the status report till that because of the non-receipt of the FSL. This is the status report.
Administrative council public. Applicant. Also have Mr. Theatre. Additional PP to the state next period. By filing this application under section 439 reads section 167 within bracket 2 bracket small a bracket close bracket Roman small Roman bracket close of the criminal procedure code 1973 for grant of for a release, praying for release of the accused person on default bail. In connection with the PS case number 52 of 2023 under section 21B.
Yes, subsection B, small b. Greater than smaller quantity and lesser than commercial quantity.
Under section 21 within bracket small b bracket plus NDPS Act 1985. The applicant was arrested on 10/9/2023.
Yes, your lordship.
In connection with the above referred case. The PS case number so and so, huh?
And remand on 11th, your lordship. That it will be computed from day of remand, your lordship.
Yes. And they remanded on
11/9/23, next day.
11/9/2023. Thereby, he is in jail for more than 60 days.
More than 60 days, perhaps 66 days on as on date. 65 days because today is not complete yet.
More than 66 days.
65 days. Yes.
65 days as on today. the learned counsel Mr. Tita proposed that in view of the provisions under section 166 within bracket 2 same huh 67 bracket 2 within bracket 2 bracket close bracket small a bracket close small so and so same. Are you getting it? Here to see the accused person is entitled to default bail for which the accused person shall be released on bail by operation of default bail. Listen. On yesterday, na?
Yes, sir.
15/5/20. No, the learned edition of PP was directed to obtain instruction as regards the as to whether the charge sheet has been filed or not. By placing the communication that the 15/11/2023 learned edition PP clearly submits that the case is still pending investigation for non-receipt of FSL report. Expert on having considered the commissions and the law. Provisions of the law that the right to get default bail is an indefeasible right, and this right must be exercised by the accused by opting to furnish bail. In the case of Rakesh Kumar Paul versus State of Assam, recorded in 2017, 15 SCC 67, the Honorable Supreme Court has said, has held that in all the cases where the minimum sentence is less than 10 years, but the maximum sentence is not death or life imprisonment, then section 167, bracket 2, bracket close, same, huh? Same, so will apply and the accused will be entitled to grant of default bail after 60 days in case charge sheet is not filed. Next one. Having considered that the accused applicant, accused Mr. So and so shall be released on bail forthwith on furnishing of bail. That's all.
Yeah, Lordship, and stipulated period may be granted that he has to execute the bond within so and so period. If he failed to do so, then it will be forfeited because it's an indefeasible right, Your Lordship.
On furnishing bail bond within a
Yes, Your Lordship. Within a week, Your Lord, from today.
within a week.
Yeah,
Unless you furnish it, you will not wait. But you
Yes.
said forthwith.
Yes, Your Lordship.
Huh?
If he failed to do so within a week, then it will be
Say
forfeited.
forthwith
Yes, Your Lord, not forfeit within
on furnishing a bail bond within 1 week.
within 1 week. Yes. From today, Your Lord.
From today.
Yes. Deeply obliged. Also.
I'll just correct those sentences later on. Sir, what is this?
The response from the respondent number 2 and 3 has been everything since Malak 2019.
You take press steps. What the
My
last
lord,
steps you have taken?
recently, I have taken the press step on 21st September 2020.
No, September is not recently. It's after 3 months. It's been 3 months, September, October, November.
And my lord, I may not take broad in my lord, what he can start. Broad officer is that can start. Itanagar officer, police station of Itanagar.
Last occasion also, it was also, notice was issued for the OCP concern. And, as per office note, issue a notice to the R2 respondent to return unserved.
You find out the correct address, you take persist. Office note dated 15/11/20. No, 20, where this is 23, 28, 23. Reflects that notice of respondent number 2 has returned unserved. In view of the above, the learning council to the petition is permitted to take fresh steps.
Broad OCPS Itanagar.
So consent police station by registered post with 80 as well as by usual process within 7 days from today. This matter after 3 weeks. Sir, what is this? What should be done today?
This was issued by the service. Control is not yet complete. AD card has not been done.
Service on 13, no? We'll
Yes,
wait for some time.
Fine.
Mr. within Learned Council for the petitioner. Next para. Office note reflects that service of notice of the sole response is awaited. This matter after 3 weeks.
Could I pray for a date?
And you just suggest
19 December.
19 December. List this matter on 19, 12, 20.
Deep.
What is this?
The service is completed, Lordship, upon respondent. Service is completed upon respondent number 2, Lordship.
Completed.
Lordship. And Lordship, one Lordship, this same Lordship, matter Lordship 51, 2023 Lordship should be Lordship clubbed together, Lordship. Out of same Lordship petition. That is
Mr.
51
you are
to
for
22.
petitioner.
Yes, madam.
Mr.
L. Tikak.
So and so, Learned Council. Present? No, Mr. So and so, Learned Council. Appears for, no, Mr. So and so is present. And also MSL has a additional people. Office note dated 15/11/2023 reflects that notice upon respondent number 2 has been duly served. Mr. MSL Hage, let me submit that an analogous matter
Lordship.
is also pending before this court.
That is 51,
Analogous
23.
matter being criminal petition.
Lordship, 51,
51
2023.
of 2023
Lordship.
is also pending before this court. In view of that, she submits that this matter will take along the criminal petition 51 of 2020.
Lordship, there's an interim in this matter.
The criminal petition 51 of 2023, we take with this letter. List after 3 weeks. Interim order was earlier continued.
Attachment.
Sorry, my lord, next in court number 1. My lord, Here the appellant matter has filed this appeal against order, challenging an order dated 12/12/2022, by which a injunction in their favor was, my lord, modified. My lord, in the memorandum appeal I have seen, the records are not complete, my lord. The records may be required. Even the application on the basis of which the injunction was granted by the deputy commissioner at that point of time, that is also not enclosed.
We'll call for the record. Has it not been called, or just we'll have to ask a reminder?
My lord, I have subsequently appeared, my lord, maybe in the first order, I'm not sure.
Sorry, my lord, I was on lakes.
We will call for the records.
Correct, my lord. Interim order to continue.
Heard Mr. Vichita, learned counsel to the British appellant, and also heard Mr. Deepak, learned counsel to the respondents.
Well,
Sole respondents.
three, my lord.
Yeah, three respondents.
Three respondents.
All respondents.
All respondents.
For all the respondents. Call for the lower court's records. Mr. This matter after, on receipt of the LCA.
LCA. Interim order to continue.
Interim order plus arrest and continue.
Great.
This report in respect of still awaited. Heard Mr. K. Lon and learned counsel to the also heard Mr. Spencer.
Yes.
Reminder to I was service report on respondent number 2. Yes.
reminder for LCR. Reminder registry may be reminded for LCR because LCR is called for not to receive.
The LCR to issue reminder for LCR. List this matter after 3 weeks. In the meantime, also there is an interim order plus earlier still continue.
Problem.
I'm agreed by the cancellation of thereby the special judge of Africa. My bail was cancelled only on the ground because my counsel failed to appear on 3 consecutive days.
Have you received the LCR?
No. LC received, yes. Here in this case, LC received. Matter is pending for 313.
What about service?
Here, service is not necessary because court has so much to cancel the bail.
Heard Mr. So and so learned counsel. The G. Kato learned counsel to the petitioner. And also heard Mr. B. Kato learned petitioner to office note dated 15/11/2023 reflects that service report in respect of respondent number 2 is yet to be received. Okay, list this matter after 2 weeks.
My lord,
when did you take the steps? Have you taken steps?
Yes, my lord.
We'll wait for some time.
So in this case, this can be heard in the absence of the victim also, because I have not violated any terms and conditions of the bail, only because my counsel had failed to appear on the date of cross-examination of IO.
Lordship, the facts of the case is that the
anybody appear
No, Lordship, they have received, but they have not appeared, Lordship. On 2 occasions, we had waited.
When it was received?
Lordship, it was received in the month of August, Lordship. According to the order, in the last order, Lordship, accordingly, it was reflected that
Maybe it was received in the state was the- Let us give one more chance. There's nothing.
actually
It will be allowed. It will be allowed. Your petition will be allowed. So therefore, this court would like to give one more chance. All right.
Lordship, our small date, a small date,
Huh?
short date may be given, Lordship. A short period.
If you give short date, it will have no meaning adjourning the matter, giving them a chance. Since heard Mr. So-and-so, Mr. Even after service of notice. Upon the respondent number 1.
On a respondent number, all the respondent.
All the respondent, service notice, even after serving of, even after receipt of notice. No, the respondents, comma, even after receipt of notice is yet to appear. One last chance is given to the respondents. Take appropriate steps. Dismissal after 3 weeks. Is there urgency? No.
There is regarding the certificate.
3 weeks.
We will take fresh steps, Lordship. Much appreciated.
I've heard you yesterday. Anything?
That's it.
Well, you will leave it to this court.
Okay, that's yesterday, Lordship, my this senior counsel Lordship, she submitted that there's no prima facie Lordship. There's no prima facie Lordship, material Lordship, while the impugn order was passed, Lordship. Lordship, I am submitting Lordship today, Lordship, at the stage of Lordship, consideration of charge of framing of issue, Lordship. What is required is considered is whether there is a ground for presuming that an offense has been committed or not, and not the ground for committing the accused has been made out, Lordship. And so at this stage of court cannot be hold mini trial, Lordship. And Lordship, regarding that, Lordship, Section 227 to 228 Lordship, CRPC Lordship, I am publishing this, Lordship.
Yes.
Lordship, para 8.1 Lordship and 8.5 Lordship.
Facts. What about the facts? Do you have anything to say?
Lordship, everything, Lordship, this, well.
Facts not disputed.
Lordship. Lordship. May I, Lordship?
8.1.
8.1, Lordship.
Yes.
Lordship, in Suresh and this court had an occasion to consider in detail the scope of the proceeding stage of framing of the charge section under section 227 to 28 CRPC. After considering earlier decision of the court on the point whether there are paras 2930, this court has observed the held and under, Lordship. We have bestowed our consideration to the Rebel Commission and the submissions made by Mr. This comment as true. It is at the time of the consideration of the application for discharge, the court cannot be as a mouthpiece of the prosecution or act and act as a post office and massive evidence in order to find out whether or not the allegation made are groundless or as to pass an order of discharge. It is right that at the stage of consideration of application for discharge, the court has to proceed with an assumption that the materials brought on record by the prosecution are true and evaluate the said materials and document with a view to find out whether the effect emerging therefrom taken at their face value disclose the existence of all the ingredients constituting the alleged offense. At this stage, probative value of the materials has to be gone into, and the court is not expected to go deep into the matter and hold that the materials would not warrant a conviction. In our opinion, what needs to be considered is whether there is a ground for presuming that the offense has been committed and not whether a ground for convicting the accused has been made out. To put it differently, if the court thinks that the accused might have committed the offense on the basis of the materials on record on its probative value, it can frame the charge. So for conviction, the court has to come to the conclusion that the accused has committed the offense. The law does not permit a mini trial at this stage. And Lordship, 8.5 Lordship.
That is her case. It supports her.
No, Lordship, here Lordship, what is the ground Lordship? This Lordship during the framing of charge Lordship, the Lordship they have IL Lordship petition they have filed Lordship for discharge of the Lordship petition Lordship, which is Lordship rejected Lordship because their prima facie case made out Lordship. So their impugn order have their challenge in the revision petition.
Yes, that's what I'm saying.
Lordship.
This case, there cannot be a mini trial.
Lordship, that's why Lordship.
At this stage of framing.
Everything Lordship, this is prima facie clear Lordship. This prima facie is their Lordship. So Lordship is
how prima facie?
Lordship, their Lordship, they have made out the ground Lordship in the impugn order Lordship. On the basis of that, they have find that this is prima facie case well established. So their petition, there's IA is.
So according to you, this the whatever is recorded in the impugn order.
Lordship.
It is based on the prima
Lordship.
facie view of the court, which the trial court can frame on the prima facie view of the court.
Lordship.
Then?
Lordship, 8.5 Lordship.
8.5. You are skipping 8.4.
May I Lordship, applying the law laid down which court in aforesaid decisions and considering the scope of inquiring at the stage of framing of the charge under section 227 to 28 CRPC, where the opinion that the submission made by land counsel appearing on the behalf of the affair on the merit at this stage are not required to be considered, whether submissions are made by the land counsel appearing on behalf of the prisoner are required to be dealt with and considered as appropriate stage during the course of the trial. Some of the submissions may be considered to be defense of the accused. Some of the submissions made by the land counsel appearing on behalf of the appellant on the conduct of the victim are required to be dealt with and considered at an appropriate stage during the trial. The same are not required to be considered stage of framing of the charge. On considering the matter on record, we are of the opinion that there is more than a prima facie case against the accused for which he is required to be tried. There is sufficient ample matter against the accused, and therefore the land trial court has rightly framed the charge against the accused and same is rightly confirmed by the High Court. No interference of the court is called for.
See, here the allegation, the offense is under section 3 of PDPA Act. What does PDPA Act say?
Lordship, this is Lordship, the mischief Lordship.
Let us assume that the water has vanished.
Lordship.
There's nothing on record to show that that has been at the behest of the accused.
Lordship, now as per the record, this water was not there, Lordship. It is the Lordship onus upon them, Lordship, to show that
rather
they have
there's an evidence of
Lordship.
record to support that it has what do we call it? Collapse.
Lordship.
During the rainy season.
But this is
And
only
the documents which the accused relied at the time of framing charges by filing an application for discharge, that has not been taken into consideration. Because it appears to be the documents, of course, subject to proof in the trial.
Lordship.
But that is a kind of private process. It's not you have seen it yesterday.
Lordship,
It has been received in 2003. and it has collapsed or vanished
This was.
in 2019. Is not it?
Yes.
2019 or
2019.
19. And
Lordship,
the complaint was
As part of complaint in 2020.
2020.
Lordship, that's why Lordship, the court has to look into Lordship. But Mary Lordship,
And obviously, I mean, it is not permissible. Had it been a case that the quarter has vanished on that plot, if the buildings comes up,
Lordship.
then
But that is their defense Lordship, that's the weather condition Lordship. But there's no proof Lordship on that part also Lordship.
on premises, since you are on prima facie, why
Lordship.
also on premises?
Because of private facie Lordship, they have they consider Lordship that because the court below, that CGM court, they also not really Lordship incompetent Lordship that
They don't go by their personal knowledge.
that's why Lordship tries.
At this point, it is only repetition.
Then that's it, Lordship. This is my submission, Lordship.
Because I'm not going to, I mean, this court will not apply what is personal knowledge, but
Yes.
there is cases where the quarter has vanished and the multi-story building, there is a big sort, I mean, the officers and some contractors, we have seen it. But we're not going to get that thing into it. We'll go by the materials on the record.
Lordship.
Isn't it?
Anything Lordship pass any order, it would be Lordship blanket order. It would be a blanket order, Lordship.
Blanket.
Lordship.
No, this cannot be.
Because Lordship.
Court's order cannot be a blanket as such.
Lordship, because
But the court may have a different interpretation.
Lordship.
Therefore, there is an appeal provision.
But we have to
Suppose
Lordship.
this court will pass to the best of his knowledge and ability, not just a blanket order.
It can be presumed to Lordship. Other party will.
I admit, we're human being.
Too much.
Everyone does have a limitation. All right. But system as such is that there's the appeal provision. But the court never will pass an order, I mean, blanket order. They'll apply their mind best of their ability and knowledge. Order is passed, not the blanket order. That you did not have that conception on the court.
I'm apologize for that, Lordship. Lordship, this is my submission, Lordship. Only this judgment, Lordship. It's regarding the Lordship, the framing of charge and consideration, Lordship.
This is Tarunjit Tejpal.
Lordship. The
Section
Supreme Court SSC Lordship, 2020, 17,
Yes.
SSC 556.
Have you gone through the facts of the matter?
Lordship, this
I
is
think
Lordship.
this is Tarun Tejpal, that
Lordship.
That,
do you call?
the
Goa-
is
Goa-
news
Goa
is
matter.
there's a CCTV footage. No, that some news agency.
Yes.
This is a famous journalist.
Yes.
Tehelka.
Tehelka.
It's a Goa matter.
Yes.
Anyway. That's
Okay.
all. I'll pass the order. And don't know, we'll let you know.
Any order, Lordship, we have accepted.
Huh?
Any order we have accepted, Lordship.
You have given the judgment, you have argued it, and considered all the aspect and pass the order. So dispose of, or should I say CAB?
It's up to your Lordship.
CAB, it's a big problem. When you say CAB, so just sell it, dispose of.
Oblige.
But in fact, the moment it is ready, it will be uploaded.
Yes.
So you'll be informed
Yes.
the
oblige.
moment it is disposed of.
Yes.
So dispose of, hearing concluded, dispose of. You just record our mistake. I think. Oh. I didn't allow.
We have to look for the file, Lordship, because we have not received the file, Lordship. This unlisted item number 29.
Unlisted. They've asked for permission to unlisted and they are not here. What is this? this matter has been put up on as unlisted on the prayer of the 11th Council for the petition. However, none appeals for the petition on call. List after 4 weeks. Sorry. Next week. 1 week, after 1 week, 4 weeks. Well, this is not done. You have sought a permission, listed, and you are not like that.